Guy came in to see me a couple of years ago. He had a contempt of court hearing set 3 days later. The problem is he had been out of work for about 6 or 8 months. As a matter of fact, he had just gotten out of the hospital. He had had a leg amputated. They were going to try to lock him up for not paying child support. He was $12,000 behind. Well, I went around for the next couple of days and gathered up medical records from the medical providers. And when we went to court, we presented all of that to the judge, presented my client to the judge, and the judge says, I can't find him in contempt. But what the judge had to do was set the arrearage at $12,000. I immediately filed a petition to stop child support. And that was granted, but it was granted about 3 or 4 months later. And it was granted retroactive to the date that I filed it. He still had that $12,000 arrearage. Even though he didn't work during that 6 or 8 month period prior when the arrearage is built up, it still exists because he hadn't filed anything to stop it. And that's the key. You got to do that. Jill was a 23-year-old mother of a 3-year-old little boy. She was hooked on drugs, and I mean bad. She wanted to get clean and sober for the benefit of her child and herself. So she worked out a deal with her mother, the grandmother of the child, where the grandmother would keep the child while she was in rehab. So she went into rehab, gave the grandmother the child, and then grandmother went down to juvenile court and had the child declared dependent neglected and got custody of the child. When mom got out, she said, I want my child back. Grandmother said, no, I'm going to keep him. He's doing fine with me. So mom petitioned the court, and guess what? The court said, no, child's doing fine with grandmother. Here was the problem. Although mom had changed and her circumstances had changed, the child's hadn't. The child was with grandmother. The child was doing well in school. The child was well conditioned. And so since there was no change in the circumstances of the child, only in the mom, the court did not give mother her child back. What do you think about that? Don't get legal advice from an armchair lawyer. What's an armchair lawyer? Well, it's a person that sits around and pontificates about the law, even though they're not a lawyer and know very little about the law. The problem is that when you do that, when you listen to people, you're probably going through a high emotional issue, divorce, a child custody case, something that's got your emotions up here. And you're going to have a tendency to listen to anybody that will talk to you because you're going through that emotional time in your life. And you're susceptible to people giving you all kinds of advice, and people will give you advice. Here's the deal, though. If you are getting advice, legal advice from someone who's not a lawyer, then you're getting bad advice. If you have a lawyer and you don't feel like your lawyer's doing a good job, get another lawyer. But don't get advice from people that are not lawyers. It's not going to help your case. I can't tell you how many times I've represented dads in cases where DCS has done an investigation and they never communicated with the father because they didn't care to find out who the father was. They did the investigation without any knowledge of the father. Now, if you're a father and you get wind of the fact that there's a DCS, Department of Children's Services, or Children's Services, whatever you call it where you are, if there's an investigation going on involving one of your children, you've got to be proactive and contact the department to let them know that you're the father and you want to participate and be involved in that investigation. You have a right to know what's going on with your kids anytime they're being investigated by the Department of Children's Services. But you've got to be proactive and don't back down. You've got to be persistent and proactive. It's difficult to get in touch with people at DCS sometimes. You've got to stay on them. Does your lawyer know the rules of evidence? If not, you might want to get another lawyer. Tell you what, evidence is the backbone of our legal system, our litigation system. If you don't understand the rules of evidence as a lawyer or layperson, you're going to get trampled. Had a case a couple of months ago, young lawyer on the other side. He had a good case, he just didn't know how to present it because he did not understand the rules of evidence. He wasn't really a litigator, and what he was doing in court, I don't know. But he was there and I was there. I understood the rules of evidence. I used it to my client's advantage. I probably shouldn't have won that case, but I did just because he didn't understand the rules of evidence. If you're a layperson and you're trying to go to court against a lawyer, you're going to have a difficult time because most good lawyers understand the rules of evidence. And you're going to be up against a lawyer who should understand those rules. And when objections come out, it's going to be difficult for you to respond to those objections without a knowledge and experience dealing with the rules of evidence.